Dear students, dear colleagues, dear friends, dear Chiara and dear Maria as well. It's a pleasure to be present here today for this public lecture on environmental justice and public participation law matters. I'm particularly pleased to introduce this series of guest lecture that takes place within the framework of the Jean Monnet Centre of EUqualis, that is coordinated by the Institute of European Studies of the ULB. For those who were here already on Wednesday, we had the opening of the academic year with Laurent Warouzet discussing the history of Europe. And today we continue our exploration of European integration and topical issues in that field by having the pleasure of welcoming Maria Lee to discuss the question on environmental justice and public participation. And this issue is closely linked to the topic of the Jean Monnet Centre of Excellence, which deals with the question of how the EU addresses the questions of inequalities and in environmental matters, inequality matters, as the measures taken to mitigate climate change or to ensure environmental protection might have a different impact depending on the group concerns. And so it's with great pleasure that we welcome Maria Lee and that we are very much looking forward to a fascinating lecture. And I give the floor to Maria.
We've been waiting for this for months, and now here we are. The students know that we've been talking about this lecture for many weeks. So I'm absolutely delighted to have you here, Maria. Professor Maria Lee is Professor of Law at University College London, UCL, the other UCL for the Belgians. And she's also been co-director of the Centre for Law and Environment at UCL. Professor Lee is one of the greatest voices in environmental law in Europe and in the UK. And we're extremely lucky to have her today. She's been working on the role of law and the ways in which law shapes environmental decision-making. She's been interested in particular on the role of technologies, technical, complex matters. And what I like about her work is her way of shaping and using her analysis to understand the role of law in the ways it defines the governance of decision-making, but also in the ways it interacts with expertise and participation. So that's why it's a really great privilege to have her here today. I'm not going to tell you all about her writing. There are two books that have just been released, one of which is a co-authorship and a collection on planning, and the other one, which is really a milestone now in the literature, on expertise and a use that NGOs make of legal expertise. So without further ado, thank you so much for being here, for doing the trip, and we are really looking forward to hear your lecture. Thank you.
Thank you. Thank you so much, both of you. They were very, very kind introductions. I've been looking forward to coming here for ages, so it's great to be here now. Thank you so much. Thank you for the invitation, Chiara. So the harder we think about environmental justice, the more inadequate the tools available to lawyers seem to be. But we can't afford to neglect the negative and the positive contributions of law in this area. Law matters, institutions matter. Otherwise, we simply depend on the goodwill of those with power. So I'm going to begin today with various dimensions of environmental and ecological justice, and then I'll turn to public participation and its role in justice, and we can review perhaps some of the legal provisions on participation and think about the ways in which legally protected rights to participate in environmental decision-making support those who strive for environmental justice. We must also, I think, attend to the ways in which public participation fails to contribute to environmental justice and may even exacerbate existing inequalities. And finally today, we'll think about law and lawyers and our role in environmental justice. Again, law matters, I think. Law is not innocent in the challenges that we face here, but nor is law incorrigible. It can be improved. So environmental justice is incredibly difficult and complex. It's dynamic, it's constantly expanding to try to capture previously overlooked or undervalued issues. Activism and social movements, as well as scholarship, contribute to the construction of complex ideas of environmental justice. And what follows will, of course, simplify a little bit, but I think we'll get some of the complexity. I'm not going to offer a formula or a definition of environmental justice, as David Schlossberg puts it in this really wonderful book, if you're interested in the area. Environmental justice is plural. I am going to talk about these three dimensions of environmental justice. Those dimensions are not comprehensive. You'll be thinking of other types of justice as I stand here, I'm sure. Happy to talk about that at the end if you'd like to. But let's start with distribution. Environmental problems, from air pollution to biodiversity destruction, affect us all, but they don't affect us all equally. And the classic work is this report, the United Church of Christ's 1987 Commission on Racial Justice. And this report found, in quite a groundbreaking way, that US waste sites and hazardous waste facilities were significantly associated with lower household incomes and with higher percentages of residents of colour. 1987, and in England now, areas suffering from the worst air quality are among the most deprived in England. And those areas also have a higher proportion of people of colour living in them. And environmental justice and injustice isn't just about what we get, the air pollution, it's also in our contribution to the problem. So in that English report, the people living in these areas are also 3 times less likely to own a car than the average population. So they contribute least to the problem of air pollution. Justice is about both sides of the equation, the winners, the losers. We talk about this dual dimension of justice most often with respect to climate change, where those who contributed least to the problem and have reaped fewest rewards from our fossil fuel economy, they are the people who bear the worst of the consequences. And we will come back to that. But just in case you're thinking this is somebody else's problem, these are European Environment Agency reports. This research, interestingly, I mean, we could speculate about why, but the European Environment Agency focuses on poverty rather than on race or ethnicity. It finds inequalities in the distribution of environmental goods and bads that are probably fairly familiar by now. So there's less and lower quality green space in communities of lower socioeconomic status. On climate change, higher temperatures, flooding have an uneven impact attributable to personal vulnerabilities, age, health, disability. Same with air quality, disproportionate impact. And those with poorer socioeconomic circumstances are both more exposed and less able to avoid or recover from the impacts of climate change or from poor air quality. And this leads us into a bigger question about what we are distributing. What are the material issues at stake here? Part of the environmental justice movement, and I think this is really important, was about a shift of focus away from what we might call charismatic megafauna, pandas, polar bears, away from a focus on the cult of wilderness, towards the environmentalism of the everyday, as Agyeman and his colleagues put it in that paper, towards working class environmentalism, the environmentalism of the poor. And in addition to the environmental goods and bads we've already talked about today, we also extend environmental justice into a potentially unlimited range of underpinnings to social justice. So illustrated on the slide, we have climate justice, energy justice, food justice, water justice, which all sit within this range of environmental justice. I think the extension is important. Social justice and environmental justice are tightly bound up with these goods. And I think these goods belong properly on the environmental agenda. However, I have to sit with some discomfort when I see this expanding range of issues for environmental justice. I have to work out where that discomfort comes from. I don't think it's about a parity of concern between good, healthy food and a good environment. I think that's right. I think my anxiety comes from the concern that social justice is very often simply converted into money, and hence into that age-old competitor to environmental protection. So there's a danger that the emancipatory extension of environmental justice could be transformed into an objective of just economic growth, a bigger pie, as our government in England would put it. And you forget the focus on equality and justice. So my discomfort, which I must just sit with, at least points to a need to be alert to the danger of this most progressive of ideas being co-opted by business as usual. It happens all the time. We need to look out for it. This question of material distribution in a world where many bear extraordinary burdens of environmental degradation whilst others reap the benefits, this has to be a central concern of environmental justice, distributive issues. But it's not sufficient. Justice as recognition emphasises the notion that our dignity, our humanity, is partly social. To be a full human being with dignity requires us to be recognised as such by others. It's also a question of status, equality in standing and significance. And a failure to recognise others as equals may be one of the underpinning structures supporting an unjust distribution. And I'm sure you're thinking that, yes, of course, everyone deserves equal recognition. Good. But perhaps we see a failure of recognition when really decent people just accept that more expensive residential areas are bound to be less polluted. They're bound to have more beautiful parks, and vice versa. If it's cleaner air and better parks, it's going to be more expensive. And lots of people have that instinctive reaction, but that involves assuming that places with cheaper, poorer homes, i.e. poorer people, will also be more polluted and have less quality green or blue space. And I think that whenever we hear anyone argue that environmental distribution, so distribution of environmental goods and environmental bads along socio-economic lines is natural, it's an inevitable way of the world, rather than an injustice, we see a failure of recognition. We see recognition justice in play. The instinct shows us how ingrained market instincts are, and it also, I think, shows us how thinking in terms of justice can make us challenge our own inevitable, we all feel it, can make us challenge our own failures of recognition. Underpinning Iris Young's work is an interest in the underlying reasons for injustice. And her work on structural injustice, and I've put Robin Eckersley up there because Robin Eckersley applies this to the climate context. So her work on structural injustice speaks to these underlying reasons. So taking climate, there might be clear identifiable wrongdoing on climate. I'm sure we can think of wrongdoing. But many, perhaps most, climate injustices are done by multitudes of small, frequent actions by all of us. They're just normal. They're not necessarily blameworthy. It might not be helpful to think of them in terms of blame. And so the idea, I think, or one of the ideas, and one of the important ideas, is to capture justice questions without getting tied up in identifying evildoers. Yeah, you don't have to be a bad person to be committing injustices when we start thinking like this. Justice as recognition focuses on the politics of difference, the idea that equality can oppress. This can manifest distributionally, so the same air quality standards, equal quality standards, can be fine for most people, but oppressive if you're in poor health or in poor housing, for example. We'll come back to the ideas of difference and participation in a moment. Let's think about procedural justice. Just as I said a moment ago that environmental problems don't affect us all equally, so we don't all have equal rights or equal abilities to have our say on the processes that either create or try to solve our environmental problems. Procedural justice is tightly linked to both distributive justice and justice as recognition. An unfair process is unlikely to lead to fair distribution. If we don't hear from diverse communities, we're less likely properly to take their needs into account. And in the day-to-day routines of environmental business, permitting, licensing, standard setting, in those day-to-day routines, ensuring that people can participate, procedural justice, can render the evidence and the values on which decisions are based open to question. You know, we can question the evidence, we can question the values. But procedural justice isn't just instrumental about better outcomes. It's also normative, it's democratic, it's about ensuring we can contribute to the shape of our worlds, it's about political equality, it's about recognition. Who makes decisions and how? This is the stuff of justice, and it's also the stuff of law. This is what we do. And perhaps we're satisfied with voting in an election every 4 or 5 years. I'd suggest we want something more. The top 3 examples on the slide are the most common forms of participation. It's a simple consultation, an opportunity to make a contribution to a process, generally in writing, sometimes in a public meeting. Or we might have something more ambitious, something like a citizens' assembly or some other form of more deliberative exercise. And then there's everything in between. Environmental justice, as I said at the beginning, is dynamic. The powerful language of justice, the demand for justice, began with the observation that racialized hierarchies are reflected in environmental conditions. Feminist scholars were then at the forefront of justice as recognition and the politics of difference. You might be thinking about intergenerational justice in this context of the human dimensions of justice. And many of you will probably be thinking about injustice towards the global south, the continuing injustices of colonisation. And on this question of scale, of the global question, we're often concerned with the local, with relationships between communities grounded in place, where we live and work and play, as it is often put. If we think about the European Union, scales get complex. We might stick with the local, particular disadvantaged communities. We might think about justice between member states, and the EEA reports that I mentioned earlier really focus on relationships between the member states, northern and western, southern and eastern member states. Is the harm distributed equally? Do they have an equal say in how it's resolved? But if we think globally, we're immediately confronted by the EU's disproportionate historical and ongoing contribution to our various environmental crises. And global environmental justice raises a whole fresh set of questions. Now, these are UNICEF images of recent extreme flooding in Pakistan and Mozambique, millions harmed, millions displaced, and those millions made a minimal contribution to climate change and have drawn minimal benefits from our fossil fuel economy. The distributive issues could not be clearer. Those who contributed least suffer most. The procedural and the recognition issues, though, are also, I think, fairly clear. We might note the dominance of the concerns of the rich global north over the global south in law and in politics. We might think about the neglect of historic responsibilities for climate change, and until recently, the relative neglect of adaptation or loss and damage. We can think about all of these things in terms of justice. There is an important strand of scholarship that takes us beyond the human. From an anthropocentric perspective, this recognises that we are not separate from our environment. It emphasises our utter dependence on ecosystems and the non-human environment. But ecological justice and multi-species justice goes beyond that to think about justice for the non-human. The argument goes that the domination and exploitation of humans and non-human nature all come from the same place, and we need to respond to all of it. Again, I'm a bit uncomfortable. So there's a real value and there's a real generosity in this expansion. I suspect it's probably ultimately necessary to think about justice to others if we're to respond to our crises. But this time my concern, my discomfort, is the fear that multi-species justice might move us away from the environmentalism of the everyday, the environmentalism of the poor, right back to the wilderness and the polar bears and pandas. Whose values and whose interests does that serve? I've nothing against polar bears and pandas, by the way. We should protect them. The expansion into ecosystem justice positively, so it's a good thing, emphasises that the human and the non-human cannot be separated, and that ecosystems should be prioritised over the economy, over money, over buildings and artefacts. Yes, that's positive. But is it melodramatic of me to fear that deprioritising the human might lead us to some dark places? Perhaps it is melodramatic of me, I don't know, but I feel this discomfort, perhaps because I haven't paid enough attention to the ways of thinking about the environment in the global south or amongst communities of poor environmental activism. Perhaps I need to work harder. But again, I think we need to be alert to the fragility of our emancipatory ambition for ideas like environmental justice. So we have an extraordinarily complex range of issues and of values. As with Schlossberg, I see this as plural. There are multiple ways of thinking about justice in any single case. We can't pin it down. We probably shouldn't try to. We should try to bear the ambiguity lightly. That's quite hard for lawyers. We don't like to bear ambiguity. Thinking about public participation in terms of justice, we're thinking about procedural justice, a normative demand for fair processes, but not just that demand for fair processes. We're thinking about fair processes leading to fair outcomes. We're thinking about recognising the status and perspectives of diverse groups, which involves including them in decision making. So what does it look like when the law protects public participation? Well, to be honest, it looks a little bit banal if we stack it against our severe and our pressing environmental crises. But I think banal bits of law really, really matter. The institutions of justice include some quite boring legal protections of public participation. The Aarhus Convention is perhaps our core legal mechanism for addressing procedural justice. The Aarhus Convention makes different arrangements for different moments in decision making. I know that most of the people in this room went through this with Chiara this morning, so I won't take many moments over this. So first of all, activities under Article 6, things like the physical building of a wind farm or a coal-fired power station, a waste incinerator, licensing a factory. That has the strongest requirements, with a focus on good information to the public, on early consultation while all options are open, on paying due account to those who take part, and there's an obligation to give reasons for a decision. Article 7, plans and programmes, like a transport plan or a water resources plan, similar protections. In addition, there's a very sparse obligation to endeavour, to the extent appropriate, to apply public participation to policies relating to the environment. And then we turn to laws. What are we thinking about here? So British non-governmental organisations have recently brought 2 claims before the Aarhus Compliance Committee, alleging inadequate participation in 2 cases under Article 8. One is about what became the EU Withdrawal Act 2018, so the legislation basically arranging our legal system for withdrawal from the European Union. There was no participation in the pre-parliamentary stage of preparing that legislation. That's one case. The second case is about the preparation of trade agreements after Brexit. In the UK, this is still a very closed process, like same as it was in the 19th century, basically. So these are going to be really interesting decisions as to where Article 8 takes us. I mean, the requirement under Article 8 is to strive to promote public participation. So it's soft, it's quite soft, but striving is not nothing. I would like someone to strive to include me in these decisions. In 1998, the Aarhus Convention was extraordinarily progressive. It was really important, and it's still really important. It creates legal rights for publics to be consulted, with some protections as to timing and taking account. It creates a special place for environmental NGOs, and so the environmental interest. It's modest, though. It's pretty thin. I think it probably has a more ambitious soul. I think at heart it would like to do more than mere consultation, but in its legal requirements, it's fairly thin. And by 2022, the Aarhus Convention looks like a bare minimum. It's still the best we've got, though. I'm not going to go through this slide, but we see Aarhus implemented through EU legislation. Environmental assessment is the key mechanism. Environmental assessment, crucial, absolutely vital to procedural environmental justice. Again, it's pretty thin, it's pretty minimalist. I think the job of law here is to strengthen the links between environmental justice and public participation, to reduce the possibilities of conflict. Legally protected rights to participate in environmental decision-making do have something to contribute, but the legal protection of those rights is not the end of the inquiry, it's the beginning. Because we have to be conscious that rights to participate can reflect and intensify, rather than breaking down, existing inequalities. The limitations of public participation exercises of routine consultation in practice are just far too familiar. Participation requires time, mobility, literacy, communication skills, often specialist or expertise of some variety. And these resources are unevenly distributed, okay, so that participation can reinforce existing inequalities. What you really need in your community when you're participating is a judge or a professor of air quality or biodiversity. And ideally they'll be retired, so they've got loads of time to contribute to this participatory process. And these practical issues lead us to more conceptual questions around the democratic and problem-solving potential of process. Who and which interests are present? Is anybody listening, or has the decision already been made? In short, we might have formal equality, a formally equal right to participate, but going back to the idea of justice as recognition and the politics of difference, simply inviting people in to be heard assumes that everybody is equally able to identify and then articulate their interests. There's resonance with justice as recognition every time we hear disrespect for the involvement of the less highly educated or the less expert. Partly because of the barriers to ordinary participation, we ask environmental groups to mediate. The difficulty is, of course, that, whilst NGOs can amplify the voice of the marginalised, they aren't particularly representative themselves. And there's a lot of debate about that in the UK at the moment. Perhaps environmental NGOs are better thought of as a crucial counterweight to the dominance of economic interests. They represent environmental interests rather than people. And some sort of representative role is necessary if we're to think about ecological or multi-species justice. So it's important to recognise the justice limitations of rights to participate. The job is not done once we have protections in law. On the other hand, they're a necessary minimum. And legal protection of rights to participate means that inclusion is not in the hands of the powerful. And we have to remember that economic interests, industry, whatever, will always be consulted. So it's really worrying that even the minimal rights of Aarhus and environmental assessment are under pressure. In England, post-Brexit, there's a real resistance from government to be bound by legal procedures. Environmental assessment is seen as alien, that word is actually used, alien EU red tape. And environmental assessment is a serious candidate for deregulation. The bill on the slide goes beyond that, beyond the routine erosion of day-to-day procedural justice. Very wide powers are granted in this bill to, well, not even powers to do it. So in this bill, government could restate, revoke, replace retained EU law. But more importantly, there's this sunset clause, which means that all retained EU law, including environmental assessment, but also everything else, will simply disappear at the end of next year. Okay, no parliamentary procedure, no consultation, no impact assessment. We are dependent on the discretion and the competence of whoever happens to be in government next year to save a great bulk of environmental law. This is what can go wrong. Okay, so procedural justice is under pressure, I think, from the highest to the more mundane level. Some of us Brits might be in danger of being nostalgic for the European Union, but as Professor Armeni reminds us, all is not necessarily well in the European Union either. So, you know, perhaps we have a devalued approach to participation in the climate law, in the climate pact. And this work, which is trying to bring together responses to the environmental crisis and responses to the energy crisis, is focusing on speeding up renewable energy development. And I won't go through it now, but that's in large part about removing the need for environmental impact assessment of individual projects for renewable energy in particular identified zones. Okay, so we just get rid of environmental impact assessment. Now, these proposals are much more limited in their scope than the UK approach. There's more justification for them as well, I think. But they show, as in the UK, that procedure is vulnerable when it is inconvenient. And in an echo of the UK, there was no consultation, no impact assessment on that second proposal. I know there are concerns about barriers to renewable energy infrastructure. Procedures need to be purposeful and as efficient as they can be. That demands resources for regulatory agencies and consultees. It requires political prioritisation, not just of outcomes, but also of procedure. And I think that is somewhat recognised in the Commission's approach. On the other hand, the UK government is explicitly, expressly rejecting legal process. Excuse me while I just take a drink. So there are at least three things that make me think that we need more rather than less participation. First, yes, of course, we need to avoid the local trap being the assumption that those local to a development are necessarily the most legitimate participants. And that sometimes is a consequence of our existing models, including the EIA model. But we need more participation. We need a way to bring in the interests of those beyond the local community. Legal measures might include, for example, institutions to represent those distant in space or time. And you can do that without dismissing the justice issues for the local community. My second concern is the complexity of the empirical position. Who and what in detail are the winners and the losers from the different options? Having fewer voices will not help us work out what the empirical situation is. We need more voices, not fewer. Thirdly, and perhaps most pressingly, is this the start of something? Will our participatory rights also be eroded for fossil fuel hungry, but also urgent economic development? The likelihood that we stop with renewable energy, I think, is remote once that line has been crossed. We also, I think, need to ask ourselves whether participation and environmental assessment really are improper barriers to renewable energy development. And the English experience might be useful here. So large onshore renewable development has stalled in England, lots of offshore, but not a lot of onshore. But I think that's in spite of, not because of, participatory rights. So first of all, rights to participate were reduced for various categories of infrastructure development, including renewable energy, but also including coal-powered fire stations and, airports. So rights to participate were first of all reduced, and there was a strong presumption in favour of development, in favour of wind farms. Communities, though, continued to resist. They said, you've got to listen to us. The fact you've not given us a space doesn't mean we're going to stop speaking. And then central government became concerned that these were the people they wanted to vote for them. And so their response was to reverse the policy presumption. And there's now a presumption against renewable energy development. And my point, I could talk all day about wind farms in the UK, and I'm sure Chiara will do that with you for one of your classes. I could talk about that all day, but the point is that rights to participate aren't the thing that's slowing this down. It's the failure to persuade, a failure to listen. It's really a failure of politics. And I think boring, routine opportunities to speak to those with power, like environmental impact assessment, would help, not hinder. Now, Chiara and I think that rights to participate matter more than ever in the climate crisis. We didn't frame this in terms of justice, this article, but I think we might say that justice isn't something that gets done to you. It requires a right to participate. Law matters. And I hope what I said about the limitations of law make it clear that it's not just the bare right that we need, it's the detail that matters. We definitely need the bare right, but the detail matters. So let's have a look at Iris Young's criteria for good, just participation. It should be fully inclusive. No one should be excluded by the practical barriers I was talking about earlier. It should be ongoing, not a one-off. The least powerful should have equal resources with those who have power, so the economic actor and government. And the community should have actual power in the decision making. This should be a final decision that no one can overturn. I'd describe these as idealistic, probably unachievable in precisely the most interesting and difficult cases. But as lawyers, we shouldn't just throw our hands up and say, well, let's not bother with participation then. We should think about how we get more justice rather than less. We should look at the features of the law that make for better rather than worse participation. And the idealised, unreachable proposals, and there are lots of criteria like this, are something to strive for. So what about the imperfect but crucial Aarhus Convention? On inclusiveness, it's far from perfect, but for example, the Aarhus Convention, Articles 6 and 7, touch on the need for decision makers to actively identify the relevant public. This isn't a passive exercise. You have to reach out to the disadvantaged. We might pay more attention to the obligation to produce non-technical summaries in environmental assessment. The Aarhus Convention makes special arrangements for NGOs, including the environmental interest. So it's insufficient, but it's not nothing. On consultation over time, there are efforts in the Aarhus Convention to go all the way through the process, from planning to policy to legislation and back again. It's not enough. We might want institutions to have broader obligations to encourage participation. We're nowhere near equal information and resources, but the Aarhus Convention really emphasises the link between information and participation. Again, we could improve it. We could insist on adequate resourcing of the public organisation running the consultation and the individuals being consulted. There's no shared decision making. This is the most challenging. I don't think it would be very helpful to have a blanket right to vote on or veto policies, activities, etc. But we do want decision makers genuinely to attend to the input to consultation. The Aarhus Convention obligation to have due account and to give reasons is the best that they think they can do. Okay, but that's about making decision makers pay attention to the input. These are minimal approaches, and we could think of lots of improvements to law here. I think paying attention to the injustices of participation and actually thinking hard about trying to improve them does matter. These provisions of Aarhus and EIA are overly familiar. We take them for granted. We don't pay a lot of attention. Perhaps we should take them more seriously, really make them mean something, and perhaps then they'll point in the direction of more rather than less justice. Participation will always fail as a tool of justice, but the perfect must not be the enemy of the good. We should strive to do things better, not abandon things that are not done well. And lawyers are well placed for that, well placed to create the structures that help participation reach towards its emancipatory potential. Won't get there, but reach towards it. Complying with Aarhus is better than not complying. Reaching out to the disadvantaged is better than not reaching out. Paying genuine and conscientious attention to the input of consultees is better than not doing. My final slide. What does this word justice add? So I think we could probably do all of the work we've done today without justice. But it is intellectually and conceptually based on decades of really rich thinking and rich activism. It clarifies, it challenges, and it sharpens the demand. This is not about charity or goodwill. This is about rights. And that's why law, again, really matters. I'll end where I began. The harder we look at environmental justice, the more inadequate the tools at the disposal of the lawyer seem to be. Inadequate in the face of crushing injustice and environmental and climate crises. But inadequate or not, they are crucial. The law on participation is not innocent in the limitations of participation, but it is not incorrigible, and we should try to improve it. The more we lose, the older I get, the more we lose the hard-won protections that we had thought were inviolable, the more I appreciate the importance of being explicit at this point. Scrutiny and criticism of good ideas is utterly necessary. Scrutiny and criticism, we need it. EIA, Aarhus, public participation, all good ideas, but we must scrutinise and criticise. But then we need to be explicit and say we're not rejecting them because they're imperfect, because we won't get to the perfect. So we strive to make the law better. We strive to improve the links between justice and participation. And again, this does seem quite banal in the face of our multiple crises. And my pragmatic, possibly bathetic, final point is that we're so very far from an environmentally just world that striving to improve it in the small ways at our disposal as lawyers is worthwhile. So thank you very much for your attention.